Hello and welcome to The Big Picture. The debate over whether children above 16 years who have come into conflict with law should be treated as children or adults for punishing them for offences committed has been raging in this country. It became more intense after the gang rape of a girl in a moving bus in Delhi in December 2012, when one of the offenders was found to be an adolescent under 18 but above 16 years. In the light of clamour from a section that tougher juvenile laws to be enacted, the government had come up with the Juvenile Justice Bill with the provision that those juveniles over 16 years accused of heinous crimes may be tried under the Indian Penal Code like any other adult. Meanwhile, the Standing Committee of the Parliament, which went into the provisions of the bill, strongly recommended against these provisions. However, the Union Cabinet has yesterday gone ahead and approved the amendments to the Act to include juveniles between 16 and 18 years to face trial among other amendments. The bill is likely to come up before the Parliament in the ongoing session. We will discuss today the amendments proposed, what it means to the juveniles in conflict with law, and whether there are adequate safeguards and whether this amendment is necessary at all. To discuss this, I have with me Dr. Satyanarayan Jatia, BJP MP and also Chairman of the Standing Committee which looked into the bill, Rajeev Gowda, Congress MP and also member of the Standing Committee, Dr. Bharti Sharma, child rights activist and former Chairperson of the Delhi Child Welfare Committee, and Aman Hingorani, advocate in the Supreme Court who has handled these kind of cases. Welcome to all of you. Dr. Jatia, you know, your committee, your Standing Committee, clearly said that this kind of amendment is not necessary, but still the government is going ahead and wants to bring about these amendments. How do you look at this?
कमेटी का काम राय देना है और उसने सभी संबंधित पक्षों से बातचीत करके इस निष्कर्ष पर पहुंची कि जो कुछ अभी विद्यमान है उसी को यथावत रखना चाहिए। और इसके भी कारण है क्योंकि कोई भी बात करने के लिए या कुछ भी नया करने के लिए निश्चित रूप से हमें बहुत सारी बातों का संदर्भ लेना होगा और उन सारे संदर्भ को देखते हुए और सब लोगों जो वहाँ पर साक्ष्य के लिए उपस्थित हुए थे और कमेटी के मेंबर की जो आम राय बनी थी उस आधार पर वो तय किया गया कि उसमें कोई परिवर्तन करने की आवश्यकता नहीं है और उसी आधार पर कमेटी ने अपनी सिफारिश करके और पार्लियामेंट के अंदर निश्चित कर दी है। हमारा काम सिफारिश करना है।
Your own party, your own government is there and the cabinet has decided that these amendments are necessary.
Not in the capacity of government, but in the capacity of the committee, and committee decided, and we told our report is there.
Okay, that's interesting that you are in the ruling party and then you have to face this kind of situation. Rajeev, how do you look at this? You know, when the committee went into these things, I'm sure you went into all the pros and cons of it. The minister, the present minister, Dr. Maneka Gandhi, seems to be very, adamant about bringing about these amendments. And they have certain arguments about this. What do you think of those arguments?
Well, first, I must congratulate Dr. Jatia for his chairmanship of the committee because it did really consider a variety of opinions and then it was not easy to build consensus. There were multiple points of view within the committee and ultimately the committee looked at the evidence, looked at international and Indian evidence and basically came up with a conclusion which is there in the very well structured and written report. Now, when you look at the minister and her taking the lead in rejecting the committee's recommendations, it seems to be founded on at least 2 or 3 main premises. One, an incorrect understanding of the data involved. She is on record of saying that 50% of crimes are committed by juveniles, etc. That is far from the truth, and the data does not reflect that. In fact, even the data that we were presented by the ministry essentially looks at FIRs filed, not necessarily convictions. So there's a lot of questions about the data that has been used by the ministry in pushing this agenda. The second issue is that maybe this is a popular thing to do, a politically potent way of demonstrating that you're taking action against
tougher laws are
you're tough on crime and things like that. Now, it's all very well to want to project that image, but you cannot do it at the cost of the Constitution, the cost of principles of justice, and certainly at the cost of internationally respected measures for rehabilitating people who are between 16 and 18. And so, in that sense, this has been triggered. This has been triggered essentially by the Nirbhaya incident that you mentioned earlier, and it is aimed at garnering political mileage, which is hardly what you need in a situation where justice must be served. And especially when children are concerned, you need rehabilitation, you need restoration, not retribution, which is what what the ministry is pushing as of now.
Dr. Bharti Sharma, what do you think? You think that this, because some of the statistics which we have clearly shows that there has been increase in the number of sexual crimes by adolescents in the age group of 16 to 18. In the last 2-3 years, there has been a rise in the number of sexual crimes, especially, and other crimes. We'll come to it later. So, you think that this kind of a tougher law will help?
I think the kind of amendment that is being proposed, it is going to criminalize more children between 16 and 18 age group. And this criminalization of 16 to 18 adolescents, it's going to be a very, very bad reverse step. Juvenile Justice Act, its principle is not retribution.
Reformation.
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 Where is reformation? It's not seen anywhere. Who are the large number of children who come before the juvenile justice system? Not those who are your and my children. They are those children. That means, by and large, children coming from underprivileged family, marginalized families, and minorities. Now, if these are the children who are coming over there, it's not because of their fault. It's because their parents cannot back them.
The environment in which they have grown.
The environment in which they have not grown, the environment in which they have been pushed into, the adults who are around them. A child at the age of 11 and 12 is asked to go to the city to earn because the parents can't cope with the 2 square meals. Now, if this child comes to Delhi, what kind of environment is being projected? So, we are criminalizing children who are anywhere into that section where they require a lot of support. I think once we raise finger at somebody, we are raising 3 fingers at ourselves. Who are ourselves? The state and the society. What did we do to see that this child does not get dragged into the criminal world? Did we? Did we give him helping hand? Once he has gone into, what is the system that is recommended in Juvenile Justice Act of 2000? Excellent act. What is the system? Is that system in place? Even in Delhi, forget the rest of the country. If that system is not placed, is the state doing anything?
What are the system which you are talking about?
System where the children are placed for reformation. That whole reformatory system, is it there? If it is not there, is the state trying to uphold and see that that system works? That system is actually present. And if not, how can you expect the child to be reformed? And punishment. No, punishment is already there. Punishment is already there.
The punishment is there, but the argument of people, who have been seeking tougher laws is that these punishments are very little. They're just 3 years or less, and then they are put in these reformation homes. It is not clear whether they actually get reformed and come out of the system. So we need tougher laws, and in the changing world, 16 years is now considered as mature enough for children to know what they're actually doing. That's the argument.
Can I give one small example? A beautiful car, fabulous one, and it's going on the road, and the brake fails. Excellent driver, excellent car, but the brake fails. What happens? It's going to dash. This is the kind of brake, the control that this particular age group of children, and it's not what I say, this is what is being proved by various studies, this control is lacking.
Okay.
And this is why this accident takes place.
Yeah, Rajeev.
Yeah, Girish, I want to underline what Dr. Sharma is saying. See, the existing framework is actually a very well-intentioned framework, and the hard work for the government would be to strengthen the rehabilitation homes, to strengthen the reformation process across the country. As she says, it may not even be properly functioning even in Delhi. So that is the hard work. This is the easy sloganeering. This is the easy public posturing. We are tough on crime. We are going to take revenge on these juveniles, especially because there is a lot of public attention. So the hard work is pushed aside. The public posturing is really what has taken prime stage here.
Okay, Aman, these laws, some of these laws which have been in force for a long time. Dr. Sharma and other guests here say that they are adequate, but those people who are arguing in favor of tougher laws say that these laws have not proved to be adequate so far.
Well, my view is that the Juvenile Justice Act needs to be amended, though not this kind of amendment as what we are seeing. I believe that the kind of amendment we need is that there should not be a blanket immunity that regardless of all circumstances, regardless of the maturity of the juvenile, regardless of his knowing the nature and the consequences of his actions, regardless of everything, he will never be put on trial. Now that blanket immunity, and that's the argument I had put before the Supreme Court while appearing for the family of Nirbhaya, seeking the prosecution of the juvenile in that case. My simple point is that this entire debate on age is irrelevant. There has to be a case-to-case basis wherever a person, regardless of whether he's 16, 17 or 18 or 15, if he has the maturity to know what he has done, he knows the nature and consequences of his actions, then he must be tried for offences under the penal code.
This is what Aman, sorry to intervene. Aman, sorry to intervene.
Maturity.
Aman, sorry to intervene.
Yes,
this is exactly the amendments which are being brought into the act, and whether
that's not the amendment. That's the point I want to clarify. If I was just to complete, the argument, the institution or the person who's going to test the maturity according to the amendment is the board. Now the board is not a court. Under the IPC, if I may just complete, if I'm given just 1 minute, under the IPC, it was a judicial function for the court to determine the maturity of the person, taking help of all experts, etc. That's a judicial function subject to appeal if the court goes wrong. Now that function, this is a half-baked measure done by the government. This function has been given to a board which is not a court. It has members who are not judicial members. The result is that this is similar to the waiver system in the US, where the board feels this is a case where the court should try the person. Now that is not what our constitutional setup is. That's not what, there's a demarcation between judicial function and legislative function. Parliament cannot take away the judicial function of the court to determine whether this person should be tried by the criminal court under the IPC. And for that, to that extent, the Juvenile Justice Act has to be amended. The amendments are twofold. One is to introduce a mental maturity of the juvenile. The other is to cap it between 16 to 18. Now, which study says that a person is bound to be mature between 16 to 18? In some recent studies, a person has been held not to be mature even till the age of 21. Where do you draw the line? Is it 16? Is it 18? Is it 21? Is it 15? Is 15 years, 11 months immature and 16 years, 1 month mature? The whole debate on juvenile has been reduced to age. And that is only one part of the whole issue. The point I'm trying to make again and again is that test the maturity on a case-by-case basis, and that maturity is to be tested by the courts.
So you don't want
the board.
One second.
There's a punishment. There's a punishment under the JJ Act.
Yes. Aman, if I have understood you right, yes, you are saying that the present provision in the proposed amendments is that the Juvenile Justice Board will decide about the maturity of the person. Yeah. You are saying that the Juvenile Justice Board should not have this right it should be done by the court itself. Is that what you're trying to say?
Yes, because this is the judicial function. The board is only a forum for rehabilitation. It does not exercise its powers judiciously. There is no prosecution. There is no punishment. It is a child-friendly inquiry which is conducted when the offence is committed. If they don't act, they might have the trappings of a court where you might have an inquiry, because that's where you have somebody conducting the inquiry, you might have some evidence being recorded, but the purpose is to reform and to rehabilitate. It is not, and for that purpose, see the guilt. It is not to prosecute a person, it is not to punish a person.
So you want
that's the reason this is a judicial function. The way for lunacy,
Aman,
lunacy, if there's in a case, yes.
Aman, are you trying to say that this present provision will not is not enough to punish the child or the juvenile? You say that he has directly to be taken to the court. See, this is a halfway measure which has been employed here, and you don't like the halfway measure.
This is at a tangent. If I may say, this is at a tangent. It may cause more injustice to the juveniles, because there would be an arbitrary application who to send to the court, who not to send to the court. I'll just give a very small example. Suppose somebody is of unsound mind. If the person, it's not the hospital who decides that. It's a judicial function for a court to declare him to be on unsound mind. Court can take help of experts. Similarly, whether a person is mentally mature or not, that's a judicial function subject to the checks and balances of appeal.
Okay.
And that discretion can be exercised by the court by taking help of taking recourse to experts.
Okay. Dr. Bharti Sharma, would you like to respond to it?
I have 2 points to make. One is that the amendment says that the Juvenile Justice Board, which has been just referred, will decide whether a child has committed an act with a child's mind or with an adult's mind.
And it's and whether he is capable of committing a criminal act.
Yeah.
That also needs to will be decided.
There is nothing on this earth that exists that can say that whether somebody has done it with a child's mind or with an adult's mind. There is no scientific way. It also talks of psychiatrists and psychologists that will
and social workers.
The board to decide this. But no psychologist or no psychiatrist can do that, one thing. And we are not talking of Delhi. We are talking of a small district in Jharkhand and Bihar and all our other states. From where are they going to get those psychiatrists? How many psychiatrists we have in the whole country? Apart from this, deciding child's mind or adult's mind is impossible. So this is, I don't know how can a Juvenile Justice Board, and even talking of the High Court.
He's talking of the courts. He says Juvenile Justice Board should not be deciding this.
Even the court cannot decide this.
Jatia?
बोर्ड का होना ये बताता है कि किसी भी
I'll come to you, Aman, I'll come to you, please wait.
किसी भी व्यक्ति को कोई भी सजा के लिए या किसी भी उसके एक्ट के लिए सजा देने की कार्रवाई करना, उसके पहले बोर्ड को बीच में लाने का अर्थ ही यही है कि उसकी गंभीरता को देखने का एक उपाय है। और यदि वो सारी बातों को देखने के बाद यदि उसकी राय बनती है, जो कि बड़ी मुश्किल से बनती है, और इसलिए इस सारी बात में से यह इन्फ्रेंस नहीं निकालना चाहिए, यह निष्कर्ष नहीं निकालना चाहिए कि वो जो बोर्ड के पास जाने वाला है वह आखिरी फाइनल है, क्योंकि वो तो उसकी राय है, उसका मशवरा है कि कोर्ट ने क्या करना चाहिए। इट इज़ द कोर्ट विच उसको टास्क पर लेना है उसने।
In fact, no, if I was going through your report, in fact your report says that even juvenile justice boards will not are not adequate to really decide whether
not to decide, it is to advise.
Recommend. Yeah, Rajeev, this whole business. What Aman is saying is that these amendments are also not enough. It should have been tougher.
No. See, the question is about case by case, right?
Yes.
So,
I'm not saying it should be tougher. I'm sorry, it should be a different model.
A different model.
So Aman's model.
You call it different model. I'm sure a lot of activists would say you're seeking for a tougher laws because you don't even want this intermediate juvenile justice board to decide. You want the courts to decide with the help of the same psychologists, psychiatrists.
No, it's not intermediate. What happens? under the unamended.
अनलिमिटेड टाइम नहीं है उसके पास.
4 months.
Okay, Aman, let Rajeev Gowda come in here. I'll come
May I
back to
say
you.
something?
Yes.
Yeah, so my concern
Yes,
is,
please.
you see,
Please.
even
Yes.
his point is more focused on the fact that the courts have judicial
Authority.
discretion, authority and power. While the fact of the matter is what Dr. Bharti Sharma and Dr. Jatia have all pointed out, how do you have the capacity to assess whether a child is a child or an adult? And then, what is that capacity only available at the court level through advisory participation? Or can we have this across the country at every district? So these are much more complicated practical issues that arise before us. Now, I don't think a case by case will also necessarily push justice forward, because those cases like the Nirbhaya case, which are much more prominent, may find may be adjudicated in a particular way compared to, and that would be a miscarriage of justice if publicity, trial by media and other such things affect the outcome of a particular
Absolutely.
judicial
And
proceeding.
this 1 month, time limit to decide whether this adolescent had the mind of an adult to commit this kind of a crime.
उसके लिए कुछ समय जो निर्धारित किया गया है उसमें उसको ये देखना है कि वो उस प्रकार की मानसिकता का है या नहीं, और इसके साथ साथ ये भी है कि ये जो उसका सामाजिक सरोकारों से भी जुड़ाव होता है, उसके कारण से वो देख सके कि वो जो लोग होंगे वो उस सारे बारे में परिपक्व भी उनको माना जाता है, और इसलिए उस आधार पर वो तय करने में मददगार हो सकते हैं कि यह सही क्या है, और इसलिए सच्चाई तक पहुंचने का एक रास्ता उसको बनाने के लिए एक उपाय किया गया है.
Yeah, Dr. Sharma.
My another argument over here is that we are discriminating children between 16 and 18 who are called adolescents.
Right.
This is against the Constitution.
Yes.
How can you call 16 to 18 as adult? He's not an adult. And how can you put this group of children into the adult, transfer them into adult criminal justice system? This is totally injustice to this group of children. And secondly, it does not say rape, and it does not say even murder only.
It talks of heinous crimes.
Heinous, that
7 years and above. Yeah.
7 years and above. So many offenses come under that. How many children are we pushing into Tihar jail? In the adult system, I mean by that. Are we doing the right thing? What happens at the end of a child's being transferred to adult system? There are least options for the child to be reformed. There are more options for the child to upgrade his skills into criminal world.
Okay. Yes, Aman.
This is via media. This is
let me get Aman.
All the comments actually support. What I've been saying. All I'm talking about is slightly different model. As per the existing law, the minute the police officers, they arrest the person, they have to produce him before the magistrate. The magistrate today only sees whether if a person is juvenile as per the age and sends to the board. All I'm saying is at that stage, the magistrate applies a judicial mind to see whether that person has the maturity. And I don't buy this argument that it can never be done. The Indian Penal Code, prior to the Juvenile Justice Act, from 1800s onwards, contains those provisions empowering courts to test the mental maturity. For people under the IPC, those under 7 can never commit a crime. Between 7 to 12, the court tests the maturity. I also don't, and so that's why the system is in place. The courts can take help of experts the way they do it for mentally unsound persons. Having said that, I also do not buy this argument that you cannot send people from 16 to 18 into the jails. Nobody is saying send them to jails with adults. Within the jail system, within the IPC model, you can have segregation of those who are below 18, treat them differently, put them in more conducive environment.
Where is the provision for that, Aman? Where is the provision for that in the IPC to be? Where is the provision?
That is the international conventions. No country in the world, even the Beijing Convention, if you look at it, No country in the world gives a blanket immunity to everyone under 18 and says the police can't touch them, courts can't touch them, they'll never be prosecuted or punished, put them only in an observation home. And we know the conditions of observation homes.
That is a different debate itself with the condition of observation. No, but the thing is, Aman, my question is this. You know, if you're saying that on the one hand you say this whole debate based on age is an irrelevant debate, it should not be based on age. So when you say that, it means that even a 14-year-old child, if he is suspected or alleged or accused of any crime, any heinous crime, then you say that if this, according to your formula, the court will decide whether this child has had the mental capacity to commit this kind of a crime. So age does not matter, you say. So and take it on a case-to-case basis. Tell me, in a country of this size, with the kind of huge cases which we see in this country, is it practical to see these things on a case-to-case basis at all?
If I may answer that, that's not my formula. Don't attribute it to me. That's the IPC. That's been the law which has been here for more than 100 years before the Juvenile Justice Act.
No, obviously that law was not working. That's why a Juvenile Justice Act was brought into place.
No. Now, what has happened, after that you have the international conventions, which have been completely misconstrued by the government of the day, and they brought in a blanket immunity, which is not even what the international convention says. Even the international convention says you should avoid putting them in jail unless they are committing heinous crimes. You are going even above what the international conventions say. Where do you get that from? You have to realize one thing. When we talk of child rights, suppose there's a minor who rapes a minor girl of 5-year-old, what about her rights? If a person is
Dr. Sharma, okay, let me get your.
I say
I got your point, Aman.
I'll just finish this.
Yeah.
I'll just finish this. A person is 14-year-old. He commits an offense. You send him to the observation home. Maximum rehabilitation period is 3 years. He is 17 years old. All your child activists certify that he is still hardened. He will commit a crime. Law is helpless. Courts are helpless. Police is helpless. You have to release him in society to commit another crime.
Okay.
So what about the rights of those, the victims of the children who are victims of these offenders?
Okay, I got your point. Yes, Dr. Sharma.
See, the basic tenet...
Quickly, we are running out of time.
The basic tenet of Juvenile Justice Act and the system is reformation.
Absolutely.
Give a chance to a child and provide those opportunities, not just in vacuum.
And it is not that these adolescents who have been found of committing crime are not being punished. They are being punished.
Yes, there is a punishment.
Yes.
It is a punishment. It doesn't look punishment to you because you are not transferring
Aman, you
to
think
the
that it is not enough. The punishment is not enough.
It's a reformation.
How can a person... No, I'm not saying it's not enough. I'm saying a person commits rape at the age of 17, he knows what he's doing. How can you not know you're committing rape?
that is the contentious issue. You say that they know, we do. A lot of people think that they don't know. Yes, Dr. Jatia.
जब तक वयस्क नहीं बन जाए 18 साल की उम्र को पार ना कर ले तब तक किसी भी बच्चे को किशोर को
Aman, please. Aman, please.
किसी भी किशोर या बच्चे को जिसने 18 साल की उम्र को प्राप्त नहीं कर लिया है उसको सुधरने का, उसको उसमें ठीक नागरिक संस्कार होने का एक मौका दे करके हम उसको अच्छा नागरिक बनाना चाहते हैं। इसके पीछे सुधारात्मक भी है और निश्चित रूप से इस देश के लिए अच्छे नागरिकों को आगे बढ़ाने के लिए यदि कोई कमी रह गई है तो उसका उपाय भी है। इसलिए इसको पूरे कानून के रूप में या इसको उस सारे पेज में जाने की जरूरत नहीं है।
Okay, very quickly, we have run out of time.
Any law will not necessarily be perfect, but you want to see the balance of effects. And you want to make sure that there are fewer people unjustly punished, even if one or two escape from this whole framework. And the way this law is crafted right now, it has tremendous potential for misuse. It has the potential for lots of new youngsters to be brought in for crimes other than murder and rape, because those are all defined as heinous and worthy of more than 7 years punishment. So in effect, you are going to create many more negative impacts through the kinds of provisions that have been introduced here than the positive impact that you would like to have in terms of tackling crime.
Okay, I think we have completely run out of time. This is a debate. I'm sure there will be a more interesting debate we will witness in the Parliament when this bill comes up there. But obviously, there are different points of view. The government seems to have rejected that point of view of the standing committee, but we'll wait and watch what will happen in the Parliament when this bill comes up for discussion. Thanks to all my guests. Please keep watching. We'll come back with another issue, big picture, same time tomorrow.